This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
First of all, my lord, at the outset, it's my duty to point out to your lordship, before anything else, that NCW, apart from the issue of jurisdiction, which is a question which is to be decided by my lord, they have disentitled themselves from even going into anything. We participate in terms of your lordship's direction virtually on a particular day, and thereafter, my lord, the NCW, the concerned person, insists on physical presence of two of my subordinate officers. The two subordinate officers pay a visit on the 23rd of July. After that, this is what is being done, circulated on every social media, including YouTube, Facebook, everything, saying Birbhum Jela Police dui adhikarik gelen Jatiyo Mohila Commission. Now, this is, and thereafter, kindly take this.
No, but who has done that?
NCW. This is the NCW. Kindly see this. This is inside the NCW. সেই নথিপত্র নিয়ে দিল্লিতে হাজিরা বীরভূম জেলা পুলিশের দুই আধিকারিকের। If it is a actual intent is to unravel, then these should not be circulated like this. Without, if your lordship wants, I can put it on affidavit.
Put this on affidavit.
I shall give a reply on that.
Because how did this TV channel get these photographs of inside?
Let them put an affidavit. We shall file it. Maybe they have given it only. It may happen also.
I will give it.
Whoever it is, I don't know.
Who knows?
But the thing is,
সেই নথিপত্র নিয়ে দিল্লিতে হাজিরা বীরভূম জেলা পুলিশের দুই আধিকারিকের। If the intent is to act as per the provisions contained in the act, then these things, it is not something, a mudslinging which is going on.
No, but I don't think, I don't know. But suppose live streaming is going on over here.
Maybe this is not live streaming.
I don't know.
With respect, this is not live
streaming is going on in my court. Yes. If the present situation is being telecast subsequently, or a still photograph of the same is being uploaded somewhere, that is not true.
It was, in fact, on the first day when the matter was moved, an incident did take place in your lordship's court today, with only as an officer of court, not meaning any disrespect to anyone. A lot of interactions, verbal, interactions take place inside court.
Yes, do take place.
The other day, my learned friend, and very rightly so, I am not saying that he has done it wrongly, castigated one of my officers. That portion, only that portion, all over the world knew about it. I am telling your lordship,
and there is no law.
The person from Delhi sent it to me. Said, what is going on?
There is no law which we can prevent that also.
That is the very big difficulty.
So therefore,
one except for your lordship's observation is taken.
I understand. So if this is a direct live streaming going on,
not direct live streaming.
I don't know, sir. Nowadays, courts are running by live streaming. I don't know.
They have to make an averment that from the NCW's office, some of the officers has done it.
Because this is being done by NCW. The video streaming, the live streaming, the photographer. I did not have any mechanism there apart from collecting, carrying certain documents which they insisted.
No, I understand that, but then earlier it was.
I did make ABP live also.
Earlier it was easy. Now, how this photo is now it is very difficult, sir. Now,
I am not saying Mr. Mujumdar or his.
No, but. If this was done in a manner, see, every proceeding has its own. These are all. This is investigation going on. This is not a court proceedings going on.
100%.
What is going on is in the form of an inquiry or investigation going on. That attaches to it some secrecy. But if their rules permit the AM to live stream the proceedings, I cannot as a court.
Live streaming. Live streaming is not permitted because what is
first and order? What is here to circulate it?
What is troubling me, when I was informed of this, that I will first, at the outset bring it to the notice of the court that this should stop. There is a connected hearing, sometimes stated, next week or the week of 13th or 14th of August. Now, it was initially 11th. There's a demise in the family of the person concerned, and I'm told, Milord, it has been rescheduled on the 13th. Now, Milord, what I was principally on is, Milord, kindly protect my clients from this verbal abuse at the instance of all and sundry who do not even know what's going on. Milord, if the intention is to protect women and their credentials, their everything, this should not take place. That is my only submission.
What you are saying?
That is my only submission.
Verbal abuse? Which verbal abuse?
Verbal abuse by all and sundry. This is being circulated in Facebook and people are commenting.
So we will come to that.
And that is one aspect. The other aspect today is, before your lordship. On the first day that we made submissions, we indicated
to... I'm sorry. It চলবে hearing.
Today the issue before your lordship only is NCW and its power. How far does it stretch in order to rope in and conduct a parallel investigation over a particular matter where, in pursuance of an FIR registered and taken cognizance of by the police, an investigation is going on and all endeavor is being made to ascertain the correctness of the allegation. In the teeth of that, my first submission to your lordship is, please take, the affidavit in opposition. Now, in paragraph 15 of the writ petition, this is how.
Which paragraph of the affidavit of opposition?
First is opposition is paragraph 11, and in paragraph 15, please first come to the paragraph 15 of the writ petition. It is a politically motivated thing which is going on, nothing else. In paragraph 15, what we have stated is, it was subsequently revealed there a written complaint was lodged by some women of Birbhum district on 2nd June before the respondent number 1. However, to protect the identity in this sensitive case, the said complaint is not being disclosed along with this writ petition. To which, my lord, in paragraph 11, direct attack on my clients. What is the attack? By none other than the person who is incidentally, my lord, named respondent here. My lord, respondent number 3, she has affirmed the affidavit in opposition. It is by her. She says in paragraph 11, in response to paragraph 15, that the respondent number 1 states that it is shocking and a matter of grave concern that a specific complaint dated this, which is specifically pleaded to be kept secret and deals with the safety and security of women and their families in that particular area, had gone into the hands of the petitioners as well as the investigating agency. In no way this document could have reached until and unless the investigating agency has used its undue influence to obtain the same. If things to be seen at larger perspective, this document could put the families of those who have complained to the NCW at great jeopardy, considering the attending circumstances prevailing in the same district and in that area. Pausing here. My response may kindly be looked into, my lord. In response to paragraph 11,
sit.
Please see first. I request my lord to kindly
paragraph
11, paragraph 12 of the affidavit in reply, page 11, page 15. But first, your lordship kindly takes the trouble to come to page 41 of the reply.
41 of the reply. Yes.
My lord, the deponent who has affirmed the affidavit, being the respondent number 3, was also
এই যে মেলটাকে এইটা ক্লিক করলে
very good. Very good. Please see page 41. Kindly see, this is from Dipali Srivastav, addressed to the petitioner number 1, who happens to be the SP, with a copy to the respondent number 3. Please find final notice for hearing scheduled on 14th July 2025 at 12 noon in NCW office. Kindly see the two attachments. There are two attachments here. My lord, I have the original email. My lord, kindly click, my lord, the left-handed one. It is they who have given it to us. And now, in order to field the names and everything, we did not disclose anything. Please see, my lord, please click, my lord, with the left-handed one.
attachment.
Well, both. Your lordship may click both. Your lordship, before your lordship. Your lordship may click either of them or both of them. Kindly see, my lord. This was served on me. She knows it, and now she, my lord, this is how things proceed. My lord, it's a completely vitiated mindset. The idea is not. The idea, the intent is not. The intent and idea is not to act within the four corners of NCW Act. The intent and idea is, since the accused, whoever, howsoever he is, happens to be someone who is not in the same page with NCW, this particular lady, NCW's, this concerned deponent. So it's a political mind game. It's a politicized weaponry which is being used just to extract materials. On the other day, it fell from my lord in course of hearing that CD and everything cannot be insisted. I travelled, first we appeared on the first is 14th of July. At page 34 of the writ petition, 14th July document, 34 of the reply. All these were furnished. 34 of the reply.
Yes.
These are all, appended and enclosed with the reply up to, page 39. Up to page 39, all these documents are there. Then, the SDPO of Bolpur writes to the SP, that is the writ petitioner number 1, on the 13th of July, pointing out in the last two paragraphs whatever he had to say in page 40. That is also furnished. Now please see the order made at page 42 by the member, by the deponent or the respondent number 3. Please take the pains, to kindly come to page 42 for a moment. Please see, apart from anything else, what is written in paragraph 5.
Yes.
Milord, this is despite, Milord, at page 41 of the writ petition, and in the light of the explanations, Milord, which have been offered, it may not appeal to the concerned authority. It may not be found to be creditworthy. But with greatest of respect, Milord, having already solicited these documents and the matter now being under your lordship's, Milord, judicial eyes, they insisted on the entire case docket as early as on 1st of July. Milord, that is at page, Milord, 40 of the writ petition. They wanted me to appear on 1st July at 12 noon along with the entire case docket. Whereas, Milord, they have no subject to correction. First of all, Milord, he has in the affidavit in opposition, sought to suggest.
No, Mr. Bhattacharya, you don't argue these first. These are factual aspects of the case. First, argue on law. I will
and only one additional thing I'll stop.
Because
they have said that a court under Article 226 and 32 can look into everything. Milord, with all humility, Milord, the NCW is not a constitutional court. They have said that in their affidavit stand. They have quoted, Milord, a judgment, and they say from the judgment it appears that the court may insist. Court under 226 and 32. Milord, with all humility, Milord, kindly with pardons me for saying this. Milord, kindly do not allow, sitting in whatever jurisdiction that your lordship will be, Milord, in your lordship's stint as a, Milord, honorable judge of this honorable court, kindly do not allow any authority to convert itself to a constitutional court. Milord, constitutional court, Milord, with respect, Milord, 226 and 32, they have different parameters. And a proceeding under Article 226, your lordship is every day hearing a 226 matter. And a 226 reigns, Milord, supreme, with foundation is legal right. And a corresponding legal obligation, the breach of which is alleged in a writ petition, that compels, my lord, to exercise your lordship's high prerogative writ jurisdiction. That is the principle. Elementary principle. One who has a right may come to your lordship's court for the breach thereof. That is the fundamental element. Kindly do not allow any statutory authority for that matter to convert itself, or even may not plead by citing judgments that it has been converted to a constitutional court and therefore it has a right to go through the case diary and everything. Now, my lord, coming to the legal proposition that we seek to rely on, my lord, please take the act which is a part of the writ petition. My lord, that pleading, if your lordship kindly sees, my lord, that pleading is in page 16, 17, 18, particularly in page 18. By relying on a judgment, my lord, reported in 1981 to SCC 493, that is, my lord, Khatri and others, what your lordship knows better than me, my lord, what is the proposition laid down in that judgment. They have quoted, my lord, extensively, and my lord, kindly comes to paragraph 8, page 18 of the affidavit in opposition, 5 lines from the top or 6 lines from the top, my lord, they have said whatever they have said, this 32 to 26, they have quoted that portion in order to demonstrate before your lordship that they have high plenary powers, like your lordship's court, to call for anything and everything under the sun. Now, my lord, kindly takes the provisions of the act. My lord, I have annexed the act at page 44 of the writ petition. My lord, I was wondering, I was asking, my lord, instructing, my lord, my learned friends, as to what is the constitution. The constitution is spelled out in section 3 of the NCW Act, that is page 45. And my lord, the functions of the commission is spelled out extensively in section 10. And perhaps this is the first time in my entire professional career, my lord, that at 5:30 or at 3:30, my lord, I am doing a matter, and that too a hearing matter. My lord, kindly see paragraph section 10 for a moment. the commission shall perform all or any of the following functions, namely, all or any of the following functions. Investigate and examine all matters relating to the safeguards provided for women under the Constitution and other law. Present to the central government annually and at such time as the commission may deem fit reports upon the working of those safeguards. Make in such reports recommendations for the effective implementation of those safeguards for improving the conditions of women by the union or any state. Review from time to time the existing provisions of the Constitution and other laws affecting women and recommend amendments thereto so as to suggest remedial legislative measures to meet any lacuna, inadequacies or shortcomings in such legislations. My lord, after the 2012 shocking Nirbhaya case, there were various amendments which were introduced in the criminal legislation. F. Look into complaints and take suo motu notice of matters relating to deprivation of women's rights, non-implementation of laws enacted to provide protection to women and also to achieve the objective of equality and development, non-compliance of policy decisions, guidelines or instructions aimed at mitigating hardships and ensuring welfare and providing relief to women, and take up the issues arising out of such matters with appropriate authorities. This is looking into complaints. Then, call for special studies or investigation into specific problems or situations arising out of discrimination and atrocities against women and identify the constraints so as to recommend strategies for their removal. Undertake promotional and educational research so as to suggest ways of ensuring due representation of women in all spheres and identity, etc. Then, participate and advise on the planning process of socio-economic development of women. Then, kindly ignores the rest of it. Kindly come to N, any other matter which may be referred to it by the central government. Then, the central government shall, what is the duty of the central government? That is specified in 2. Then, 10.4. The commission shall, while investigating any matter, referred to in clause A or subclause I of clause F of subsection 1. That is, clause F, clause A is investigate and examine all matters relating to the safeguards provided for women under the Constitution and other law, that is A. And F1 is look into complaints and take suo motu notice relating to deprivation of women's rights. So F of subsection 1 have all the powers of civil court trying a suit, and in particular in respect of the following matters, namely summoning and enforcing the attendance of any person from any part of India and examining him on oath, requiring the discovery and production of any document, receiving evidence on affidavits, requisitioning any public record or copy thereof from any court or office, issue commissions for the examination of witnesses and documents, and any other matters which may be prescribed. Now, my lord, this cannot be stretched, requiring that, first of all, my lord, falling back to F, look into complaints and take suo motu notice of matters relating to deprivation of women's rights. The complainant's wife or mother, who was allegedly abused over that conversation, was not the complainant, as it appears from whatever, my lord, I have handed over to my lords. Look into complaints and take suo motu matters relating to deprivation of women's rights. Deprivation of women's rights is a very wide term. Look into complaints relating to deprivation of women's rights, that is F subsection 1. Investigate, 10.1a says, investigate and examine all matters relating to the safeguards provided for women under the Constitution and other law. So it is couched in a language which is very clear and very specific. So, my lord, while exercising this power, they may act as a civil court and require the discovery and production of any document. Does not mean that where, my lord, a case is registered under the appropriate criminal laws. Milord, anything and everything pertaining to the case can be looked into, because, milord, with all humility, the function has to be within the parameters of law and within the four corners thereof. Keeping this in mind, milord, then it does not say these are the functions of the commission. Pausing here, I do not see anything specifically saying that this is the power of the commission. I take it to be the function of the commission. 2, milord, 10(1)(a), 10(1)(a), 10(1)(f), and while 10(1)(a) and while 10(1)(f) act in terms of 10(4). Now, milord, please take the trouble to come to page 51. This is National Commission for Women, Regulations 2005, 51. The commission may summarily dismiss complaints of the following nature. Milord, I take it that this particular issue is directly not covered by any of these provisions. I cannot stretch it to say that there is a matter pending in the court or a tribunal, but an investigation which may lead to something before a court or a tribunal, or the, milord, here very briefly, if I may say so with respect, milord, the magistrate's permission was obtained before deciding not to upload the FIR. The magistrate was informed about the possible grounds. Milord, whatever be the grounds, they may not appeal to the NCW, but the magistrate definitely, that document is also in the reply which we have annexed. Then, milord, how a complaint is received and registered is section 3, rule 3. This is key regulation, no rule. Regulation 3. Then, milord, regulation 4 is scrutiny of complaint. Then, milord, please take, milord, the trouble to kindly come to page 53, manner of dealing with complaints. Initially dealt with by a member of the commission. Here, the only person, milord, I invited my lord to the constitution of the commission at the threshold in section 3, just to prima facie show your lordship that the commission consists of not one person or 2 persons or 3 persons, it consists of a number of persons. Because of this provision in regulation 6, the complaint shall be dealt with initially by a member of the commission, and having regard to the, however, the chairperson may, having regard to the importance of the matter, place the case, required a detailed inquiry before 2 or more members of a committee appointed in this behalf, or set up an investigating committee for the said purpose. Now, milord, please, this is one provision. Then is regulation 7. Inquiry into complaints. Call for information or report from the central government or any state government or any other authority subordinate thereto within such time as may be specified is not received except, milord, this is what is there in 7(1). Then preliminary consideration, issue of notice. Milord, this is the form of notice, enclosing a copy of the complaint thereto. Please see 8B. 8B. Pausing here for a moment, it has been alleged that we have undertaken unfair means to extract the complaint. Whereas, apart from the email that I have shown your lordship, my lord, regulation 8B specifies that a complaint has to be enclosed. Then, my lord, procedure for conducting inquiries, regulation 6. This is on receipt of information as per provision of regulation 7, etc. If so considered necessary, proceed with the complaint. Where no further action, my lord, kindly ignores it. Provided that where action has been taken as BC, my lord, this is complaint may be sent to the appropriate government for their consideration, may be referred to state police, state government, that where the action has been taken above, the same shall be monitored till the issue matter has been settled, decided. Monitor. What is to be monitored? If the complaint, where no further action is called for, the complaint may be, my lord, there is a something, my lord, in B, complaint may be sent to the appropriate government for their consideration, oblique other authorities for their consideration, provided that where the action has been taken in BC above, C is may be referred to concerned state police, state government, shall be monitored till the issue matter has been settled. Where cognizance of the complaint is taken on a suo or on suo motu action, the proceeding in the form of inquiry may be initiated. On suo motu, my lord, we are not concerned with this. This preliminary hearing of the complaint, my lord, here, this is not a suo motu action. This is on the basis of a complaint. So the proceedings in the form of inquiry may be initiated. Preliminary hearing of the complaint, at the preliminary hearing, the member shall ascertain from the complainant. Here, again, my lord, I disturb your lordship only to demonstrate before your lordship that at page 42 of the order passed on the 14th of July, my lord will not be pleased to see the presence of the complainant. Here, the complaint, if I may say so, is a weapon, is a ruse. Just to use it for the purpose of continuation of this, my lord, rigmarole by calling the police and by doing everything. Whereas, regulation 10B kindly sees such complainant may be examined on oath or may file an affidavit supporting the facts of the case, or may be directed to produce list of witnesses, documents proposed to be relied upon, if any, to support her claim. Pausing here. 14th of July, the SP appeared. This is preliminary hearing of the complaint. So, I put this question entirely to myself, whether the provision contained in regulation 10B of their regulations, was it resorted to? If not, then the complaint is just a piece of paper on the basis whereof a roving and fishing inquiry is being sought to be initiated by a person, by an authority who considers itself above everything. Super power. That they will direct, they will advise, they will be the monitor, they will be doing everything without even first attempting to make any observation regarding 10B. Subject to correction. I may be wrong, my lord, I may be corrected. Thereafter, the witnesses shall be examined and the opposite party shall have the right to cross-examine. The opposite party against whom the complaint has been made would then be required to submit his written statement of defense either on oath or on affidavit and produce list of documents, witnesses, if any. The committee or any other member investigating or inquiring into the complaint may issue a commission for examination, where a complainant then has been filed before the commission. Summons may be issued to the opposite parties to appear. Then the opposite parties to whom summons have been issued may appear in person or by pleader, if so, etc. Every summons shall be accompanied by a copy of the complaint or by a concise statement. Such summons shall be signed by the DS or law officer. I take it. Here, again, very interesting. All these notices Lord, please see, perhaps, my lord, only apart from one, the subsequent everything is in the form of a direction by none other than the respondent number 3. Only 2nd July 2025 is by the, that is a page 40, 43 of the writ petition. 43 of the writ petition is by the Under Secretary. Nothing else. Then, my lord, please fall back wherever I was placing, my lord.
We stop over here. Actually, I've got a meeting at 5:30 that has started already. Actually, these persons are moving over here. Actually, you continue on Monday.
On the 13th, kindly, I have been directed to go with the CD and everything.
Monday you come back. Monday we'll continue with the hearing.
Monday,
because once I have started a hearing, I will stop the hearing. That will be very difficult. But once 1 week, 2 weeks, I'll forget everything.
Can it be skip on Monday and Tuesday? Can it be on Wednesday?
Wednesday hearing. Wednesday they have called us that please ask them not to. Then on 13th they should not do anything.
Why I am telling you about the last occasion?
14th.
Just 1 minute. Just 1 minute. 2 officers they have sent. One is the reader. Sub inspector is a reader, and another one, the person is a legal cell officer. He has no connection with the millet. I have the video also. The question which have been put to them, they keep calm. Well, we do not know anything. I have the video. If you want to see it, so that is the reason we have called the investigating officer to come, who is acquaintance with the investigation. Your Lordship knows the reader and the officer who is attached to a legal department. He has no knowledge about this case. And I have the video to show you before Your Lordship. Here, hearing now.
I do not have any problems on Monday, but Mr. Mujumdar.
Let him continue with the hearing. You want to stay during the hearing?
I have to.
The 13th, then, my lord, kindly protect me. At least ask them to defer it for some days, 2 days, 3 days.
Let him go.
Sir, we can virtually appear if it is so insisted.
SP, Your Lordship is directed. He appeared virtually. We have nothing to say. We have requested the SP, not even a additional SP rank officer. We asked the 2 of our officer who are conversant with the fact. You please send it before us. But they kept mum. Not a single thing they know. They says we do not know anything about this case. I have the video recording.
We are
alright. We see to that 13th. You just told them, ask them. Maybe 16th I will fix the date. I intended to hear out some portion actually. Then I take a call. But instead of 13th, ask them to shift that date.
By 7 days, but nothing.
16th only. 16th Saturday.
It was on 11th. They have themselves.
13th
owing to a demise in the family.
13th to 18th is a Monday.
18th.
Just shift it to 18th.
Very good. The matter is 13th.
বুধবার কিরকম আছে একটু দেরি করে ঠান্ডা বেশি হিয়ারিং করা যায় কোর্ট ভর্তি থাকলে হিয়ারিং করা যায় না একদম এটা মিটিং রেখে দিয়েছে রিক্রুটমেন্টের একটু চালা আচ্ছা এফিডেভিট ইন অপোজিশন ফাইল অন না এসো বসে খেলতে হবে হ্যাঁ সাদা কাগজ নাও একটা শোন আস্তে আস্তে করে লেখো হ্যাঁ জোরে বলবো না affidavit in opposition filed on behalf of the respondent number 1 be kept with the recorder. Evidence of action evidence next line like evidence in reply I filed on behalf of the petitioners we also kept on the records. You be taking back this Mr. Mojumdar. This
is a copy of the court. Your Lordship can keep it. The proceeding.
The copy of the photostat copy of the proceedings submitted by Mr. Mojumdar be kept with the record. Mr. Mojumdar.
Kindly permit me to use an affidavit in closing this.
It a fair Mr. পরে দেবে আগে নামবে না
You already filed it. Why you have affidavit?
Submitted by Mr. Mojumdar be kept with the record.
Oh.
আচ্ছা Mr. Bhattacharjee intends to use the 6th leave of the court. Mr. Bhattacharjee 6th leave of the court to use an affidavit in respect of certain circulations may aid in the social network. Mr. Bhattacharjee advocate 6th leave to use an affidavit in respect of certain circulations in the social networking site as well as the news channel relating to the proceedings.
আগে supplementary টা-
Exception may be given by us.
আরে আগে ফাইল করুক তো তারপরে এইসব এইগুলোকে মাথায় নেবো না আমি লিভস লিভ শর্ট ফর by the learned advocate is granted. Let the hearing of the writ petition continue on 13th of August 2025 at 4 p.m. Mr. Bhattacharya
Hello.
and Mr. Mojumdar, I'm very serious on the issue is that this will open up all the gates for all the commissions, I'm telling you. Whoever Human Rights
I
Commission,
told them.
all the commissions, everywhere,
Yes, yes.
all over India. Each of the organizations have their own compartment of working. Today, if the same thing happens with CBI and State Human Rights Commission uncalls for the record, suppose. Same things will happen. You understand, na?
This thing, the same thing has happened, Milord, I told you, Lordship, when Milord, the ADG CID, in connection with the case, Milord, the child commission, Milord, they issued a summon to him. He said, I will not go before. Then, Milord, the commission asked Milord to arrest him. So that order was challenged by the ADG CID before this court in 2018. Now, this court initially passed an interim order staying all further proceeding. The matter went up to the Supreme Court. But few para I want to address your Lordship, which says the commission has the power, but this kind of coercive action to arrest someone, that should be at the last resort.
I am not entering into the zone because I have not dealt with these matters. I've got to decide also myself.
I may assist my brother Milord. Reported judgment. So I'll give you
Both
the
of you actually go on because either side you will be cases are actually floating. You will be this side or the other. Whatever is the issue concerned, this will open a new gate actually for litigation.
Absolutely correct. Milord, this judgment says so far as 161 and 161 fourth statement is concerned, commission cannot call for it. But so far the other material of the chart, Milord, the
Whatever it is there,
investigation is there, the commission
whatever,
can
whatever I will go into that and see the judgment rely upon that. But once we allow the commissions to how much it's been allowed, let us presume it is allowed also for the time. How much and to what degree this will spoil the investigations. Today, suppose a investigation is carried on by NIA. Somebody says human rights violation. Can say that?
There has to be a specific finding. Then only they can do so.
And it's free to finding to generated findings. I think. Please stress all of you because either the matters are like this that you can be this side or you can be that side, sir. Each of you. The thing is that this requires a application of mind regarding the powers of the commission at the investigation stage. At the trial stage, I understand they can have the leave of the court and do it. But which part this transgression to the investigation by any of the commissions, thousands of commissions are there, sir. This is Women's Commission. There's Human Rights Commission. They have much powers actually. Now there are many serious investigations going on also. I mean, suppose NIA today, NIA investigation going on, and the Human Rights Commission asks the officer to come. How much he will divulge? This is a serious concern, actually, very serious concern. All the things are to be taken away. This is not one case because once I pass an order or judgment in any form, this long-lasting until it is interfered or some modified. This will have a long-lasting effect.
No, I definitely looked into it and
please, and I am not an expert in the subject, as I say, sir. This type of subject, sir. This is not my domain.
Once again, Milord, if I hurt your Lordship's feeling, Milord, I'm sorry.
So please control yourself, Mr. Mujumdar. Please control yourself. For a litigant, don't do that. For a litigant, don't do that.
Why I raised my voice, I'm telling you, Lordship, because the other side, he was placing, this is a case of 41A. He was saying, Milord, what he was saying, your Lordship knows that. He was raising his voice.
For a client, don't do that at this
nothing in court. And your Lordship knows the cordial relationship between Milord, the bar and the bench also. And your Lordship never find I have, Milord,
that was unexpected from you, I'm telling you. That's why I
never done it, Milord. Your Lordship.
For a litigant.
I never lose my control also. Temper also.
Little bit senior on a Friday, let us go back on a
No, that is your that is your
100%, as if it is not your domain.
Chalo.
Deep